Hello, this is Court Watch with Alex Swoyer, and I'm excited to bring you the fourth episode of my podcast where we will be talking about the Supreme Court's major cases argued this month and chat briefly with one of the plaintiffs and her attorney. Lorie Smith, owner of 303 Creative, and her lawyer Kristen Waggoner of Alliance Defending Freedom joined me recently to react to the justices hearing her lawsuit. It's one of the most watched cases this term since it pits First Amendment rights against LGBTQ protections. Ms. Smith is a graphic web designer who is challenging Colorado's public accommodations law. She says she cannot create custom wedding websites for same-sex couples in violation of her faith because it communicates a message she disagrees with. But the state could penalize her under its non-discrimination law for turning away certain clients. During this episode, we'll also be joined by Mike Davis, who leads the Article 3 project and the Internet Accountability Project. He's also a former clerk to Justice Gorsuch. He'll react to Ms. Smith's case and also comment on another major legal battle involving the amount of control state legislatures have over election laws, which was argued earlier this month as well. He's also got a fiery opinion on the court still not resolving or identifying who leaked the draft opinion 7 months ago, revealing the justices were poised to overturn Roe v. Wade. But first, here's a clip from my interview with Ms. Smith and Ms. Waggoner.
I know this has been a 6-year-long court battle for you, challenging this law. And I wanted to ask you, now that the case was heard earlier this month by the justices, how that feels, knowing that the oral argument part is over, or do you feel any relief, or do you still feel like a weight on your shoulders, given that it's probably going to be months before we actually get a ruling?
Well, this has certainly been a long journey. It's been over 6 years now, and I've always remained hopeful. And as we walked out of the court after oral arguments, I remain hopeful. I am grateful for this opportunity, and I'm looking forward to the court protecting everyone's right to speak freely, not just mine, but the LGBT web designer who shouldn't be forced to communicate messages that oppose same-sex marriage. Free speech is for each and every one of us, and it's worthy of protecting.
And I know I was in the courtroom during arguments, and there were some wild examples that came up. Some of them ranged from photographing a cisgender couple who have some sort of message on their website that you might disagree with. There was one example Justice Jackson kept coming back to, which was about a photographer who only might want to photograph white children with Santa. The hypotheticals were kind of all over the place. But I thought I'd ask you, Ms. Waggoner, what did you make of some of the line of questioning that the justices threw your way during oral argument?
I think the justices are naturally testing the limits of a principle that the court has followed for over 100 years, and I believe will be upheld in this instance, and that is that free speech is for everyone. Public accommodation laws and free speech rights have peacefully coexisted for many, many decades. We've been able to protect speech, and it's illegal to decline to serve someone because of who they are. The justices, many of them on the court, rightly pointed out during oral argument that Lorie bases her decisions on what the message is that she's being asked to create and not who the person is. And we heard some of the justices echo that as well. She serves everyone, including those who identify as LGBT. But again, she's looking at what is the message you're asking me to create in this custom speech that you want me to express.
Yeah, and I remember, I think it was maybe possibly Justice Gorsuch, he basically said, so is this about what, but not whom, right? Like not discriminating against a certain client, but the actual what is the message? If the justices were to rule in your favor, what type of implications would it have? I guess like for Ms. Smith first, like personally, how would it impact your life?
Well, first of all, in terms of how the law would impact Ms. Smith as well as many others, it would mean that they don't face fines and re-education, and in other states, even jail time for declining to create custom messages that violate their beliefs. But it also means that all Americans maintain their right to be able to speak without facing government punishment. And that includes, in many jurisdictions, they have political ideology, for example, as a protected class. So Colorado's theory is that Democrats should have to write press releases and speeches for Republicans. And that's not an America any of us want to live in. And it's not what the First Amendment allows the government to do.
Yeah, I remember when we spoke previously, when we're talking about like the personal ramifications. I know there's been other small businesses. I think there was an Oregon couple who were fined $135,000, had to shut down their business because of the Oregon state law. But in the legal sense, what you were getting at too, I think you've mentioned previously to me about the number of states that have these types of laws, and even like how they can get towards, political ideology and that sort of thing. So I know it could have widespread effect. And it seems like it looks to me, sitting in the courtroom, like the justices are looking to draw a clearer line than they did a few years back when Jack Phillips brought his case before the Supreme Court, dealing with the same type of state law, trying to force him to make custom wedding cakes for same-sex couples in violation of his First Amendment rights. I really appreciate y'all's time. I know, given how the court works, this is one of its major cases, and that usually means we have to wait long to hear what the justices have to say. Do you expect a ruling to come in June?
We expect the ruling to come at least by June. It perhaps could come earlier, and we're hopeful. Colorado has relentlessly pursued Lorie and others who share her beliefs, and we're looking forward to free speech being vindicated for everyone.
Although Ms. Smith's case is one of the most watched legal battles this term, there's still a lot more going on at the court that we need to break down. The justices will be weighing the Biden administration's plan to forgive student debt for millions of borrowers in February. And they'll also be considering a couple cases challenging the amount of liability tech companies could face if their legal protections were removed. During my chat with Mike Davis, who clerked for Justice Gorsuch in 2017, he commented on how big of a deal all of these legal issues are and what rulings from the high court could look like with the 6-3 conservative majority. Thanks, Mike, for joining us. I wanted to talk first about the case that was heard on December 5th. It was Lorie Smith's 303 creative case involving her web design business and basically her objection to Colorado's public accommodations law. She says, that the law would require her, if she entered the wedding business, to make, wedding websites for couples, that she would also then have to do so for same-sex couples, which would run afoul of her faith and violate her First Amendment rights to free speech. Some examples that came up during oral arguments, there was one that Justice Jackson kept going back to about, if Lorie Smith were to win, essentially what would that mean for a photographer that wanted to create messages about the past and only photograph white children with Santa? So the examples were kind of, not necessarily specifically on point, I guess, in terms of what Lorie Smith is bringing to the court, but the hypotheticals were interesting nonetheless. And I know your old boss, Justice Gorsuch, he brought up how this issue has been before the court before with, I think he said, quote, "last time around we had cakes," referencing Jack Phillips. He's, of course, for those who aren't caught up on the Masterpiece Cake Shop case, but it was a Christian baker who says he couldn't make a custom wedding cake for a same-sex couple. I guess, this month's case, the justices looked like they're really trying to draw a line between who is like making custom work versus who is providing services. So I'm curious, if you were able to listen to the lengthy arguments, what you thought of the justices questioning this time around, and if you think we'll actually get a ruling that draws some sort of clarity on that issue between the LGBTQ protections and, of course, your First Amendment rights.
So, yeah, thank you, Alex. I split my time between Colorado and D.C. I lived in Colorado for 10 years when I followed then Judge Gorsuch out there to clerk for him the first time, and I was in the private practice of law for 10 years before I followed now Justice Gorsuch back to D.C. to help him get set up on the Supreme Court. And I'll tell you, there is no shortage of bakers or web designers who will bake any cake or design any website anyone wants. What's going on here are left-wing activists are using the law that they enacted to target Christians to try to chase them out of the public square. They're trying to make it impossible for Jack Phillips to bake a cake or this 303 creative to build websites.
Right. And we saw it with florists too, as you mentioned. Some people, I guess it was, I think the Klein family, that was Oregon, not necessarily Colorado, but it's the same type of law. And they've been fined, I think it was $135,000.
Yeah, and it's intentional. They are being targeted and hunted down by the left. This is about anti-Christian bigotry. And in our country, there's enough room for Christians. And this idea that because Christians can't bake a cake celebrating same-sex marriage, or they can't build a website celebrating same-sex marriage, that doesn't mean that they're bigots. They're not out in front of their web design shop or their cake shop with signs saying "Go away, gays" or "Gays are not welcome here." They will build a website. They will bake a cake for their wedding. They just can't write. They just cannot write the content on the cake or on the website that they think violates their Christian beliefs.
That's like one of the, to your point, I think it was Jack Phillips and Lorie Smith, they say we serve, like we have clients that are a part of the LGBT community, but they can, like you can buy a cake off the shelf, but we can't custom make something that like would violate our First Amendment rights, I guess, is maybe where the court might draw the line, right? Like between being able to walk in and buy something or services provided versus like, custom work. It's so hard to say. I think Justice Kavanaugh, he kind of summed it up. He had a question that was basically like, how do you characterize a website designer? Are they more like restaurants or jewelers and then he said like publishing houses?
Yeah, I mean, these are not like, gas stations along the road where there's not another gas station for 50 miles. They're all, like I said, there's no shortage of bakers or web designers in Colorado. They probably had a very hard time finding these Christian businesses to target because there are so many other businesses that will do business and write any content that they want. Think about it this way. What would happen, Alex, if people were targeting Muslim businesses because they would not celebrate a same-sex marriage, right? Mm-hmm. There would be outcry, and it would be justifiable outcry. It is clearly a First Amendment violation for the state of Colorado to punish this web designer or punish Jack Phillips the baker or punish a florist or punish any business because their Christian beliefs prevent them from designing a website or baking a cake celebrating same-sex marriage. Again, we have enough room in our society for Christians, and they're not out there screaming anti-gay slurs. They're literally minding their own businesses. And the intolerant ones here are the people who are targeting these Christian businesses. Those are the bigots. Those are the anti-Christian bigots.
Based on the court, what we saw from them with Jack Phillips' case, they ruled in his favor, but very narrowly. They basically said the Colorado Civil Rights Commission didn't give him a fair hearing, and they sent the case back. Now, with the 6-3, GOP appointee majority, do you think we'll get more? I think that was back when Justice Kennedy was on the court, and the arguments were kind of tailored to him. He was the swing vote at the time. Do you think now we might get more of a clear ruling on this issue?
This clearly violates the free speech clause of the First Amendment. And I think judges have lifetime tenure. They have pay protection. They're supposed to be immune from the politics. They're supposed to just figure out what the law is, apply it, and have bright line rules so people can order their affairs around whatever the ruling is. And so, yes, the court should issue a much broader ruling than they did before so we can stop this legal terrorism that the left wages against Christian bakers and web designers and florists. Christians have every right to be in the public square just like everyone else, and we need to stop this anti-Christian bigotry. And the court needs to come up with a very clear, bright line rule so people know how to order their affairs going forward, so they don't have to go through $100,000 in litigation costs and go bankrupt to try to figure out what the law is.
Mm-hmm. I also wanted to get your thoughts. I don't know with your advocacy work if you've filed a brief with like Moore v. Harper at all, but that was another major case heard this month. And that one is not necessarily, we're talking about free speech previously. This one's more, it's a little bit wonky, I think, for especially even lawyers could argue over the different points in this one, which I guess they do, right, before the justices. But essentially, the justices it was December 7th, the case was heard. They were kind of skeptical of this argument brought by, it was North Carolina Republican lawmakers. And they're basically saying they are the ones that have authority to set election law, not the courts, like what we saw, I guess, in 2020, right, where state court rulings or election officials kind of changed laws right before or during the election in some cases. This one, of course, comes after the 2020 census. The state had redrawn its congressional map. The state's highest court said that it was a partisan gerrymander, and they implemented its own, like a court-drawn map. So it's a little, I guess, in the weeds if you want to break it down and clarify, because I'm sure you'll do a better job than I just did. But it involves the Constitution's elections clause. And I guess a ruling in this case, I mean, not that we want to, definitely don't want another COVID, but this could basically set the standard of, if there was something like that again, how much intervention, I guess, state courts could have, or election officials, or if it's all the authority of state lawmakers to govern how elections are run. And in the wake of, I know, like another Donald Trump campaign, I guess there's hyper focus on this one specifically, given what happened in the past. And I was a little surprised, to be honest with you, like during oral arguments, I was in the courtroom and there was a point where Justice Barrett was actually nodding in agreement with Justice Sotomayor's line of questioning. Obviously, the two are different ideologically in terms of how they read the law. But I just thought we'd touch on this case. If you have anything to clarify, since it is a bit wonky, please do. And then I also thought I'd ask you, like, if you heard the oral arguments, what your take was, where the court might go. It seemed like they were pretty skeptical of the North Carolina GOP lawmakers' arguments in this one.
Well, they shouldn't be skeptical. It's called the Elections Clause, which is Article 1, Section 4, Clause 1 of the Constitution, which says that the time, place, and manner of holding elections for federal office are decided by state legislatures or Congress. And so what that means is whether it's redrawing House seats after redistricting every 10 years or setting the elections rules before an election, that's to be done by the state legislatures, and Congress can override that. And it's not, that power is not given to, Democrat elected state Supreme Courts or Democrat appointed commissions around the country. And that's the point is that when the North Carolina legislature redrew the House seats, that they did it according to their power under the Elections Clause of the Constitution. The problem is Republicans control a majority of state legislative seats around the country and state legislative bodies. And so, of course, Democrats don't like that because it takes away power from Democrats. So they call the Elections Clause the independent state legislature theory and say it's a theory that's, made up by right-wing activists and that their Democrat-appointed state Supreme Court judges and their Democrat-appointed commissions should override the state legislatures because of political gerrymandering, whatever the hell that means, and redraw the lines. This is about power, and you're going to see judges who actually hopefully have a backbone and they can read the words of the Constitution and see where it says that this is decided by state legislatures. Hopefully they understand state legislatures means state legislatures, and it doesn't mean state Supreme Court justices or, Mark Elias's appointee to some commission in some state. But who knows? I mean, I heard the argument as well. I think you're going to see the typical breakdown where there's Justice Thomas, Alito, Gorsuch, who can read, and they read state legislature, and they know that means state legislature. Then there are the Chief Justice, Kavanaugh, and Barrett, who take a more political and incremental approach, and they're going to come up with a 15-factor test on what state legislature means under the Constitution. At the end of the day, I think the North Carolina legislature is going to win. They may not get as good of a ruling as we would expect if you actually read the words of the Constitution.
I think you could be right, because there's one part that I found interesting during the oral arguments. It was very Justice Roberts of him, but he basically asked their attorney, hey, and page something of, I think it was like 30 something of your brief, you have more of a narrow argument or theory you're presenting. Can you expand on that? So that could be kind of the compromise, I think, what you were getting at right there. That we see. Now, okay, I am going to jump on a topic that I know you're very passionate about, given that you pre-Elon Musk were censored on social media quite a bit. I know you went into judicial advocacy work and then also have become a big critic of big tech, right? And I wanted to get your opinion about cases that the Supreme Court said that they'll take up. I think it was back in October they made the announcement. I haven't seen an oral argument date yet set, but they go to the heart of whether like social media companies like Twitter, YouTube, Google, all those internet companies, right, are shielded from liability over how they promote content. And the cases at issue involve actually victims of terrorist attacks, right, their families. And they're basically saying these companies, these tech giants, should be held responsible because they were using different algorithms and promoting content that basically helped fuel ISIS. And so I thought I'd ask you, a ruling potentially, I guess, could get to Section 230 of the Communications Decency Act, which had been always used for these companies to shield themselves from civil liability, from defamation lawsuits, right? And being held accountable. So I thought, what do you make of the court jumping into this tech space? I know in the past, Justice Thomas has said that they need to revisit Section 230.
Yeah, I don't know if I don't have a lot of confidence that the Supreme Court is going to rule the right way in these cases, because historically the courts have misinterpreted Section 230 and they read it so broadly. Essentially, Congress passed Section 230 back in, I think it was the Communications Decency Act of 1996, and it was supposed to protect the internet infants like America Online, CompuServe, Prodigy from being sued off the map by the publishers. And so what Section 230 was supposed to do is it was supposed to be a shield to protect CompuServe, America Online, Prodigy from defamation lawsuits based upon what their users post. So if I went on and said something defamatory about you, Alex, you could sue me for defamation, but you couldn't sue CompuServe for what I posted on their online bulletin board. And that was the purpose of 230, was to get the internet economy going, protect these internet infants from these defamation lawsuits that would have wiped them off the map. Fast forward, 25 plus years now, and we have transformed through these, misinterpretation of 230. 230 has turned from a shield to protect free speech to a censorship sword that these big tech platforms use to censor, silence, deplatform, and cancel conservatives and others with whom they disagree. And we have a couple cases now before the Supreme Court. One is Gonzalez versus Google, that deals with Section 230 and algorithms. What Twitter or Facebook decide to show you, to customize and tailor to you as a viewer based upon your search habits, and so they can sell you to advertisers basically through their algorithms. And then another one is a Twitter case dealing with a terrorism law, whether Twitter is liable for civilly liable for acts of terrorism for promoting these terrorist videos and content. And so that's the question: is how far does Section 230 immunity go? Does it, how much immunity do they have? And I hope the court starts scaling back the jurisprudence we've seen with Section 230 over the last 25 plus years, where it essentially it gives these big tech platforms, they're trillion-dollar monopolists. They don't need this special protection, but they get this antitrust amnesty combined with this Section 230 immunity, and they have become pariahs. They're monopolists on the market. Google, Amazon, Facebook, and Apple are trillion-dollar monopolists. They use their gatekeeping power to over online information, online commerce, to crush competition, shutter small businesses, cancel conservatives and others with whom they disagree. And we just created these monsters.
You can even make the argument, alter potential outcomes of elections with what news they allow to surface and users to be able to access.
Yeah, we just saw that with it. They literally censored the New York Post, the oldest newspaper in America, one of the oldest newspapers in America, because the New York Post was reporting accurately that Hunter Biden, the Hunter Biden laptop, that Joe Biden was compromised by his Chinese and Ukraine foreign dealings. And, you had 51 Democrat activist intel officials say this was a part of a Russian disinformation campaign, or had the hallmarks of a Russian disinformation campaign, and big tech censored the New York Post. They made it where you couldn't even access the link to the New York Post story. Not only did they take down the story off of the internet 2 weeks before the 2020 election, they made it where you couldn't even access the link. And so if you look at focus groups, if you look at polling, if the American people would have known about this New York Post reporting 2 weeks before the presidential election, there's no way President Biden would be sitting in the Oval Office. He would be President Trump. And big tech knew this, and they used their market power to to cancel one of the oldest newspapers in America. That tells you how much power they have
It's
and how
scary.
they're able to throw elections.
Yeah, it is. It's scary when you think about how, it's really, these tech companies have become the new public square, I guess you could say. But I guess, okay, well, I have two more questions for you, and I already told you, I wouldn't take too much of your time, so I feel bad. So we can touch briefly on this next one. Basically, after the holidays, it's going to be in the February sitting. The justices will hear two challenges they've granted so far to review for President Biden's plan to cancel student debt. And one of the cases was brought by a group of red states. They basically argue the president doesn't have this authority to do this. And then another case was brought by borrowers challenging his move. And the lower courts in both of these cases had ruled against the administration and issued injunctions halting, the government from going ahead and starting any of this forgiveness. And so my question for you, with your expertise on the court, is do we read anything into the fact that the Supreme Court, although they granted the cases, they've left these injunctions in place?
Well, I think that's important that they've left the injunctions in place because it shows that it generally shows that the challengers to Biden's student loan giveaway are likely to succeed on the merits. There's the case that Biden versus Nebraska is the case with the 6 states, and there's Department of Education versus Brown, which are the two borrowers. Here's the issue. It is clearly President Biden clearly did not have the statutory power to unilaterally forgive student loan debt, up to $20,000 in student loan debt for his campaign supporters and other student loan borrowers. Congress did not give the president that authority after 9/11 under the statute that Biden claims he has that power. And even if the statute did give the president that power, that you would think that statute would be unconstitutional. It's Congress's job to spend money, not the president's. And if, what is, I don't even remember what this program is, $500 billion. I mean, what would stop under President Biden's theory, what would stop the president from canceling all student debt? Why does he have to stop at $10,000 or $20,000?
And to your point, that was one of the borrowers who brought, I guess it's a few borrowers, but one of them made the argument, I guess there's $10,000 or $20,000 someone could qualify for. And he's like, hey, I qualify for 10, but why not 20? So it's
and that's just it. I mean, this is not done through legislation. President Biden is putting the country in a lot more debt unilaterally without Congress's buy-in. The question is going to be is whether the states or whether these borrowers have standing to challenge this. Even though it is clearly unconstitutional what Biden did, you have to have standing, meaning it has to be Article 3 standing. You have to have cases and controversies under the Constitution, meaning one of these people has to have been injured by President Biden's unconstitutional actions. And I think that's going to be the case. Now, generally, the federal courts seem to find a way for states to have standing. The borrowers, who knows? I mean, I'll tell you what: if the Supreme Court wimps out and tries to dodge this case because of standing, you're going to have President Biden continuing to use this statute to give away trillions of dollars, and this is just a dangerous path. If a politician can give away $1 trillion to his supporters to help him, win elections, which is, part of what he just did in this 2022 election, is get his young supporters out there to go get their Biden bucks for this student loan boondoggle. This is not going to end well for our country. The power of the purse belongs to Congress, and the Supreme Court needs to make sure that politicians understand that.
Mm-hmm. So before I let you go, I wanted to ask you, I don't want to beat a dead horse, but I have over every few weeks, every couple of months, I email the court and I ask them if there's any update on the investigation into who leaked the draft opinion back in May of the Dobbs ruling, right? And I don't really get a response. But I thought I'd ask you, it's been 7 months, and we've been told that the Supreme Court's having its own investigation into, what happened. As a former clerk, are you frustrated that there hasn't been anyone held accountable? Do you think it's damaged the court at all?
I mean, it's shocking, frankly, because it's not that hard to figure this out. Like we can pretend that we're going to look at every clerk in the building, but it clearly came from one of the 12 clerks to the 3 justices. They're the ones who had the access to the draft opinion. And more importantly, we know it wasn't a janitor or a marshal's aide or someone like that who picked up a draft out of the garbage and leaked it, because this person also leaked twice the deliberations of the Supreme Court justices, and that would just be a very small group of people who would have access to both the drafts and the internal discussions of the justices. So it'd be one of the 9 justices, which I seriously doubt it's one of the 9 justices because they have to live with each other for the rest of their lives. One of the 4 law clerks, each of the 9 justices, or the 2 to 3 administrative aides to each of the 9 justices. It's a very small universe of people. It's almost certainly a law clerk, one of the 12 law clerks, to the 3 liberal justices. It's not that hard to figure this out. You sit them down for questioning. You make them write statements. If you have to do polygraphs, do polygraphs. It's mind-boggling to me that they haven't figured this out by now. Maybe they just don't want to. Who knows? But it led to a 1 a.m. assassination attempt of Justice Kavanaugh's wife Ashley and their 2 teenage daughters in their home. So this is serious stuff. This is the most damaging leak that we've ever seen out of the Supreme Court. They tried to change. They clearly did this leak because they were trying to change a wobbling justice, like it may be a Justice Kavanaugh, by leaking this draft and getting them to reverse their vote from conference before the opinion issue. That's clearly what happens here. This is not rocket science. It's not rocket science on how you hunt down and figure out who did this. This person needs to be arrested for obstruction of justice and many other crimes and put in jail and disbarred, and make sure that they don't go off to a law firm and make millions of dollars off of their Supreme Court clerkship.
Mm-hmm. Okay, last question. I always like to ask former clerks if they have anything funny about their time at the court to share, or anything interesting or intriguing, or a little tidbit about their former boss. I think sometimes it helps humanize the court, or gives us that don't get that inside look all the time, a chance to see what it was like. So do you have anything funny or interesting to share about your time working there?
There are plenty of things that are funny and interesting. They would tell me if I said most of this stuff, but I will say, when I went in to help Justice Gorsuch get set up, along with my 3 colleagues, we were older clerks. I was 39 years old at the time, so we were not your typical clerks. But we went in there, and each year we only had 3 months. We came at the end of the term when Justice Gorsuch was confirmed, so we had like 3 months left in the term when we started. We inherited 13 cases that we had to get, be prepared to go to work right away, because we had 13 cases in 1 week that we had to be ready to go on. And when we got there, it was just amazing to me how the Supreme Court, you hear how contentious it is, and the opinions back and forth, with sometimes some biting back and forth, and these majority concurring dissenting opinions. But it's amazing to me how the Supreme Court is truly a family. The justices all get along. The clerks get along. Each set of clerks, each justice has 4 clerks again, and each set of clerks has lunch with each of the Supreme Court justices over the course of the year. And even with our just 3 months that we were there as Gorsuch's first clerks, the justices took the time to arrange their schedules when they were very busy trying to get opinions out at the end of the term, to make sure that they had lunch with the Gorsuch clerks. And so it was a very fun experience, a very unique experience. And, frankly, that's the one thing I hope that the Dobbs leak did not destroy, is that sense of trust and that sense of family within the Supreme Court. And I fear that it could have damaged that quite a bit.
Yeah. Definitely. I think sometimes too, like when you're in the courtroom and you see how the justices interact during oral arguments, they're very civil. They laugh. Like, you can see Justice Kagan and Justice Kavanaugh kind of giggling. I think it would be good for the public to see that too, because it brings, I guess, a level of civility to our political discourse that, especially in the recent years, we could use.
Absolutely. I agree.
But thank you so much, Mike. I really appreciate it. Once we get some rulings in these cases we've discussed, I'll have to have you back to break them down and tell me and our audience what that's going to mean for, the years to come.
Great. Thank you for having me on, Alex.
Thanks for tuning in to the 4th episode of Court Watch. If you have not subscribed yet, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.